Dear students, after studying this module, you will be able to learn and be aware about the need to create Information Technology Act, understand the importance of IT Act, know the penalties and punishment related to cybercrimes, discuss different ways to protect one's privacy over internet or a shared networking. Now, the Introduction to Information Technology Act of 2000. Connectivity via the internet has greatly abridged geographical distances and made communication even more rapid. While activities in this limitless universe are increasing ceaselessly, the need for laws to be formulated to govern all spheres of this new revolution was felt. In order to keep pace with the changing generation, the Indian Parliament passed Information Technology Act of 2000. The IT Act has been conceptualized on the basis of United Nations Commission on International Trade Law, that is the model law. The Act aims at providing legal recognition for transactions carried out by means of electronic data interchange and other allied means of electronic communications, commonly referred to as electronic commerce, which involves the use of alternative to paper-based methods of communication and storage of information, and aims at facilitating electronic filing of documents with the government agencies. Now, what is the need for the Act? To provide legal recognition for e-commerce as well as EDI transactions and electronic communications. The use of alternatives to paper-based methods of communication and storage of information. To facilitate electronic filing of documents with the government agencies. Now, we shall see what are the provisions of IT Act. Information Technology Act 2000 consisted of 94 sections segregated into 13 chapters. 4 schedules form part of the Act. In the year 2008 version of the Act, there are 124 sections, excluding 5 sections that have been omitted from the earlier version and 14 chapters. Schedule 1 and 2 have been replaced. Schedules 3 and 4 have been deleted. Information Technology Act 2000 addressed the following issues. First, legal recognition of electronic documents, legal recognition of digital signatures, offences and contraventions, justice dispensation systems for cybercrimes. According to Section 10A of IT Act 2000 amended in 2008, it also validates e-contracts. Email would now be a valid and legal form of communication in our country that can be duly produced and approved in a court of law. Companies shall now be able to carry out electronic commerce using the legal infrastructure provided by the Act. Digital signatures have been given legal validity and sanction in the Act. The Act now allows government to issue notification on the web, thus heralding e-governance. Statutory remedy in case if anyone breaks into companies' computer systems or network and causes damages or copies the data. Next is admissibility of electronic evidence under Indian Evidence Act. The Indian Evidence Act of 1872. The Indian Evidence Act was originally passed by the Imperial Legislative Council in 1872. During the British rule, contains a set of rules and allied issues governing admissibility of evidences in the Indian courts of law. It is applicable to the whole of India except for the state of Jammu and Kashmir. It has 11 chapters and 167 sections, and it came into force on 1st September 1872. The Indian Evidence Act undertakes 2 types of evidences, that is digital evidence or electronic evidence, which is any probative information stored or transmitted in digital form, which may be used in the court of law for investigatory trial. But before accepting digital evidence, the court needs to ascertain whether the evidence is relevant or not, is authentic or a bogus copy, the copy is acceptable or is the original electronic feed required. Further, earlier the use of electronic devices was not documented in the Indian Evidence Act. Later, amendments were made to introduce the admissibility of electronic evidence in the court of law. To introduce the acceptance of electronic evidence, Section 22A was included in the Act. This is similar to Section 22, which states that the embargo on producing oral evidence has to consider the contents of documents. Similarly, Section 22A documents the fact that oral evidence as to the contents of electronic records are not relevant unless the genuineness of electronic record produced as in the question, that is, for it to be admissible in the court, the authentication of the electronic evidence must be done. Opinion of examiner of electronic evidence. As it is already laid down, provisions under Section 45 regarding the relevancy of expert opinion referred to in Section 79A of IT Act. Now we have Section 45A to consider opinion given by an examiner of electronic evidence regarding any information transmitted or stored in any computer resource or any other electronic or digital form is called relevant fact. As in the case of other expert opinions, court may as well consider the opinion of an examiner who has given in the manner prescribed under Section 79A of the IT Act. Further, when the court has to form an opinion as to the electronic signature of any person, the opinion of the certifying authority which has issued the electronic signature certificate is also relevant under Section 47A of the Evidence Act. Next is the Bankers Books Evidence Act of 1891 and RBI Act of 1934. E-commerce refers to doing business and transactions over electronic networks, prominently the internet. Obviates the need for physical presence. Two parties may never know, see or talk to each other but still do business. Has introduced the concept of electronic delivery of products and services. Unmanned round-the-clock enterprises available always. Offences under IT Act up to 2015. Section 65 and the offences tampering with computer source documents. The punishment is imprisonment up to 3 years and with fine up to 2 lakhs of rupees. Next is Section 66, offence is hacking. Punishment is imprisonment up to 3 years with fine up to 5 lakhs. Next is Section 66A, offences sending offensive message through electronic means, and the punishment is imprisonment up to 3 years with fine. Next is digital signatures, legitimacy and use. The Act has adopted the public key infrastructure, that is PKI, for securing electronic transactions. A digital signature means an authentication of electronic record by a subscriber by means of an electronic method or procedure in accordance with the other provisions of the IT Act. Thus, a subscriber can authenticate an electronic record by affixing his digital signature. A private key is used to create a digital signature, whereas a public key is used to verify the digital signature and electronic record. They both are unique for each subscriber and together form a functioning key pair. Further, the Act provides that when any information or other matter needs to be authenticated by the signature of a person, the same can be authenticated by means of the digital signature affixed in a manner prescribed by the central government. The Act also gives the central government powers to make rules prescribing the digital signature and the manner in which it shall be affixed. The procedure to identify the person affixing the signature, the maintenance of integrity, security and confidentiality of records or payments and rules regarding any other appropriate matters. These signatures are to be authenticated by certifying authorities appointed under the Act. These authorities would have the license to issue digital signature certificates, that is DSC. The applicant must have a private key that can create a digital signature. This private key and the public key listed on the DSC must form the functioning key pair. Once the subscriber has accepted the DSC, he shall generate the key pair by applying the security procedure. Every subscriber is under an obligation to exercise reasonable care and caution to retain control of the private key corresponding to the public key listed in his DSC. The subscriber must take all precautions not to disclose the private key to any third party. If, however, the private key is compromised, he must communicate the same to the certifying authority without any delay. Next is electronic records, dispatch and acknowledgement. All electronic records sent by an originator, his agent or an information system programmed by or on his behalf are attributable to him where the originator has not agreed with the addressee that the acknowledgement of receipt of electronic data shall be given in a manner. The acknowledgement may be given by any communication by the addressee, automated or otherwise. Any conduct of the addressee sufficient to indicate to the originator that the electronic record has been received is enough. Where the originator has stipulated that it shall be binding only on receipt of acknowledgement, then unless acknowledgement has been received, it shall mean that the electronic data was never sent. Where no such stipulation was made, then the originator may give a notice to the addressee stating that no such acknowledgement has been received and specifying a time by which the acknowledgement must be received by him. If still no acknowledgement is received, he may, after giving notice to the addressee, treat the electronic data as never sent. Unless otherwise agreed, the dispatch of an electronic record occurs when it enters a computer resource outside the control of the originator. Now we will study about the compensations under IT Act. Tampering with the computer source documents. Whoever knowingly or intentionally conceals, destroys or alters or causes another to do the same with any computer source code used for a computer, computer program, computer system or computer network shall be punishable with imprisonment up to 3 years or with fine up to 2 lakhs or with both. Whoever commits hacking of the computer system shall be punished with imprisonment up to 3 years or with fine up to rupees 2 lakhs or with both. Whoever publishes or transmits or cause to be published any matter which is obscene shall be punished on first conviction with imprisonment which may extend up to 5 years with a fine up to rupees 1 lakh, and for second time and subsequent convictions imprisonment up to 10 years and a fine up to rupees 2 lakhs. The government may notify certain computer systems or networks as being protected systems. Unauthorized access to which may be punishable and with imprisonment up to 10 years in addition to a fine. Whoever makes a misrepresentation to or suppresses any material fact from the controller of certifying authorities, and whoever commits breach of confidentiality and privacy having access to electronic data under the Act shall be punished with imprisonment for a term which may extend to 2 years, or with fine which may extend to rupees 1 lakh, or with both. Penalties have also been prescribed for publishing false digital signature certificates or for the use of such certificates for fraudulent and unlawful purposes, which is imprisonment for a term which may extend to 2 years, or with fine which may extend to rupees 1 lakh, or with the both. Next is adjudication or compensation. With regard to the adjudication and compensation, damages by way of compensation not exceeding rupees 10 million may be imposed for unauthorized access, unauthorized downloading or copying of data, introduction of computer viruses or contaminants, disruption of system, denial of access or tampering with or manipulating any computer network. Computer database means a representation of information, knowledge, facts, concepts or instructions in text, image, audio, video are prepared or being prepared or produced by a computer system or computer network and are intended for the use in a computer system or computer network. Computer virus means any computer instruction, information, data or program that destroys, damages, degrades or adversely affects the performance of a computer resource or attaches itself to another computer resource and operates when a program, data or instruction is executed or some other event takes place in that computer resource. Offences outside India. The provisions of the Act shall also apply to offences or contraventions outside India if such offences or contraventions involve a computer system or computer network located in India. Next is Cyber Regulations Appellate Tribunal, that is CRAT. A Cyber Regulations Appellate Tribunal is to be set up for appeals from the order of any adjudicating officer. It consists of one person only, that is the presiding officer. No appeal shall lie from an order made by an adjudicating officer with the consent of the parties. Every appeal must be filed within a period of 45 days from the date on which the person aggrieved receives a copy of the order made by the adjudicating officer. As the person, the Act, a provision has been made to appeal from the decision of the CRAT to the High Court within 60 days of the date of communication of the order or the decision of the CRAT. Now, next is power of investigation. A police officer not below the rank of Deputy Superintendent of Police or any other officer authorized by the central government has the power to enter any public place and arrest any person without a warrant if he believes that a cyber crime has been or is about to be committed. Public place includes public conveyance, any hotel, any shop or any other place intended for use by or accessible to the public. Next is network service providers, that is ISP. Network services providers shall not be liable under this Act for any third-party information or data made available if they prove that the offence or contravention was committed without their knowledge or that they had exercised all due diligence to prevent such offence. Network service provider means an intermediary. Third-party information means any information dealt with by network service provider in his capacity as intermediary. Next is offences by companies. In respect of offences by companies, in addition to the company, every person who at the time the contravention was committed was in charge of and was responsible to the company for the conduct of the business of the company shall be guilty of the contravention unless he proves that the contravention took place without his knowledge or that he exercised all due diligence to prevent such contravention. Hence, burden of proof is on the offender in these situations. Now we shall go through some case studies. First is Andhra Pradesh tax case. Dubious tactics of a prominent businessman from Andhra Pradesh was exposed after officials of the department got hold of computers used by the accused person. The owner of the plastics firm was arrested and rupees 22 crore cash was recovered from his house by sleuths of the vigilance department. They sought an explanation from him regarding the unaccounted cash within 10 days. The accused person submitted 6,000 vouchers to prove the legitimacy of trade and thought his offence would go undetected. But after careful scrutiny of vouchers and contents of his computers, it revealed that all of them were made after raids were conducted. It later revealed that the accused was running 5 businesses under the guise of one company and used fake and computerized vouchers to show sales records and save the tax. In Australia's largest copyright infringement case, 3 university students received criminal sentences for running a website called MP3 or WMA Land, which offered more than 1,800 pirated songs for download. In light of their age at the time and the fact that they never profited from their actions, the court warranted 18-month suspended sentences for 2 of the students and an additional fine of $5,000 for one of them. Moreover, one student and a third participant were given 200 hours of community service. Third cases of China. Reportedly, China has become a leading exporter of counterfeit and pirated goods to the world. The US industry estimates the value of counterfeit goods in China at $19 billion to $24 billion, with losses to US companies exceeding $1.8 billion a year. The severe piracy problems derive from a combination of cultural, historic and economic factors and are further aggravated by inconsistent, weak enforcement by the officials. File sharing websites and networks such as Jelawat and Kuro have been developing rapidly. The distribution of P2P software claim that file sharing falls within the private use exemption to copyright. But the Supreme People's Court of China rejected this interpretation. Increasingly, copyright owners and right organizations are challenging file sharing websites on copyright infringement claims. Next is the Beijing No. 1 People's Court ruled in April 2004 that the website ChinaMP3.com violated the IP rights of Hong Kong based and ordered the site to pay $19,000 in damages. The suit concerned the unauthorized distribution of MP3 music files. The defendant argued that he had merely provided links for download and not a direct download service, and therefore should not be held responsible for the IP rights violations. According to observers, the court's ruling may prove to be significant development in the nascent field of Chinese copyright enforcement in the digital age. It will be proper in case some criteria of these case studies is referred so that the reader may read this in detail from original sources. After reading this module, you have learned about Information Technology Act of India, understood the concept of electronic evidence and its admissibility, offences under IT Act and punishments for the same, and the jurisdiction of CRAT and the next Court of Appeal.